What has caused the delay, and what is the expected timeline now for any agreement?
Well, we've been waiting 27 years to make progress on legacy. I mean, this is the unfinished business of the Good Friday Agreement. Those who negotiated that extraordinary document recognised it needed to be looked at, but they were not able to do it at the time, and there have been many attempts since, including the Legacy Act, which has, in a number of respects, to be unpicked, hence the government's commitment to repeal and replace. I would say I think we're close to being in a position to announce an agreement. If I can just say, I've been clear from the start, and it impacts upon the discussions that we've been having with the Irish government and the Taoiseach Simon Harris in particular. I mean, I want arrangements that are going to deliver effective investigations, answers for families. For me, if you say, what is the one thing that we're looking to try and achieve? It's answers for families. I've met so many families who say we still don't know what happened, and therefore is capable of commanding support across communities. That remains our objective. It's been at the heart of the discussions I've been having with the Irish government. On the shape, if I can take the opportunity just to say on the shape of the framework, I've already set out many of the things that we are intending to do, building both on the principles of the Stormont House Agreement, which was the last time an agreement was reached between the UK government and the Irish government, and reflecting on the experience of Operation Canova, and that means a significantly reformed, independent and human rights compliant commission, gives families the best chance of getting those answers, investigations that are capable of referring cases for potential prosecution where there is evidence of criminality, significant reform of ICRIR's governance and powers. That means independent oversight, ability to hold public hearings in some cases, take sworn evidence, allow families to have effective representation, much clearer conflict of interest arrangements based on the Stormont House Agreement, as well as a victims advisory group drawing on what Canova has done, maximum disclosure consistent with national security based on disclosure for public inquiries, the potential, and this is very important, for a separate information recovery body, which you have discussed as a select committee with a number of witnesses, as envisaged in the Stormont House Agreement, resumption of a number of inquests that have been prematurely halted, and I think crucially, protections for veterans who served with great distinction to keep people safe, so that when they're asked to participate in legacy process, they're treated with dignity and respect. I've already said publicly, with modern technology, there's no reason why a veteran should have to travel to Northern Ireland to answer questions. So those are the elements that I've been discussing with the Irish government, which we are pursuing. We are drafting the legislation, and we're looking to make progress as soon as we possibly can. Now, I know it doesn't quite say, and this is the date, but if you just bear with us a bit longer.
And we'd love to know the date.
I'm sure you would.
And going back to the Irish government, the committee has consistently heard criticisms of the Irish government's approach to legacy. Where do you feel cooperation with the Irish government is not sufficiently developed, and how will this be addressed?
Well, this has been the issue of the contribution that the Irish government can make to taking forward a legacy has been a very important part of the discussions that I've been having with Simon Harris, because the current position of the Irish government is brought an interstate case against the UK based on the fact that the Legacy Act not compliant with international human rights obligations, and to be able to get Ireland's support for the new arrangements that I am planning to put in place would be a very, very significant step forward, including in the provision of information for investigators who are looking into a number of cases. So that's one reason why getting an agreement with the Irish government would be hugely beneficial. And secondly, as I've already indicated, it would, I think, enable the revised arrangements to command greater confidence in Northern Ireland. If the Irish government is shown to move from its current position to one saying, well, we've talked to the British government and we are able to agree jointly on a way forward. I think that would be a very, very significant and beneficial step.
And Sir Declan Morgan, he called for the Commission's information gathering powers to be extended to Ireland. He's also stated that the Commission would need Irish and international commissioners. Is this something how is this being considered as part of the negotiations, and is it something that you are considering seriously?
Well, in looking for the idea of an oversight board for a reformed commission, something it doesn't have at the moment, which Canova does have, what I'm envisaging there is people would apply, they could come from anywhere, international, and then appointments would be made. So that is a possibility depending on who would apply for those particular positions to oversee the work of the Legacy Commission. But I'm very keen to get the maximum information made available to the Commission to enable it to do its work. And we touched on last time, Mr. Robinson asked me about the OMA inquiry and the memorandum of understanding that has been reached between the chair and the Irish government. I know we had a slightly different view of whether we thought that I thought it represented a significant development. I think it's fair to say, Mr. Robinson, you acknowledged it was some progress, but you think it fell short of what was required. And I think the fact the Irish government has done that does show a willingness, which I greatly welcome, to provide information to help families to get answers out. I will keep coming back to that in my evidence today. That is what ultimately this is about.
Thank you. Gavin Robinson.
Thanks very much, Chair, and good morning.
Good morning.
To you all. Secretary of State, what issues remain outstanding for agreement with the Irish Government?
Well, I'm not going to give a running commentary on the nature of the negotiations, but I say to the committee, I think we are close to being able to announce an agreement, and when an agreement is announced, everyone will be able to see what it is that we have agreed.
Are there any outstanding issues for agreement?
Well, we have yet to have a formal agreement, but we've made a lot of progress, is what I would say to the committee, and I'm keen that we are able to produce this and share it with everyone, and when it appears, people will be able to see what has been agreed.
Will the Irish Government's position have progressed in relation to the OMA inquiry from the MOU to more substantive and practical engagement with the issue of the OMA bomb rather than satisfying the terms of reference for UK inquiry?
Well, subsequent to the exchange that we had last time, I looked once again carefully at the terms of reference for the OMA inquiry, and there is in the, we'll just try and find the section that relates to it, there is a reference in the terms of reference where it says in little I, any other matters which are relevant to whether the OMA bombing on 15th of August, this is the terms of reference, could have been prevented by UK state authorities. To the extent that it is relevant to the issue of preventability by UK state authorities, this may include information sharing and investigations with and by state authorities in the Republic of Ireland, which is the basis of the memorandum of understanding that was agreed. I have, of course, talked to the Irish Government about OMA, but their position is well known and understood. And on the other point that you raised with me last time about whether the period of time that the Commission covers should be extended to include OMA, I would simply say there is a public inquiry taking place that was established by the previous government, and I don't see the case for having the Commission looking at it at the same time as a public inquiry is investigating what could have been done to try and prevent it. I don't think that would be a sensible approach.
In this respect, Secretary of State, you just read out one paragraph of the Memorandum of Understanding which reiterates the frustration in all of this. It is about identifying what UK state authorities could have done to prevent the atrocity at OMA. Do you accept whilst you were presenting it as significant progress and I less so, do you accept that the Irish government are under an obligation to construct their own inquiry to answer this question? What steps could the Irish government and Irish authorities have taken to prevent the bomb that was constructed in their state, transported from their state, the team returned to their state, and they were under state agency observation?
For the record, what I just read out was not from the Memorandum of Understanding.
From the terms of reference.
It was from the OMA inquiry terms of reference.
It's the same.
Pardon?
The same issue. It's all the terms of reference are framed around answering whether UK state authorities could have done more to prevent the atrocity. That means it is out with the terms of reference as to whether the Irish authorities could have done anything to prevent the atrocity, which is why Lord Justice Horner recommended in 2021 that there should be parallel inquiries at the same time. And since our exchange, and I predicted this, it is now why the Oma families are having to seek recourse through the Irish courts to compel an inquiry. So the question is the British Secretary of State, who's engaged with the Irish government and is surrendering his ability, your ability, to determine how we deal with legacy, are you pushing the Irish government? Are you seeking to create an outcome that will satisfy the desire of the Oma families to seek justice for their loved ones?
I would emphatically reject the suggestion that I am surrendering anything to anybody. Since I came into post 14 months ago, committed to repeal and replace the Legacy Act, I've been looking to try and find a way forward, which is not going to please everybody. And we have to acknowledge this, because I read very carefully the summary of the evidence you'd taken when you wrote to me, Chair, in June, and on the one hand people said they want this, and on the other hand people said they want that, and those two views are not reconcilable in a number of respects. So it falls to the government to try and find a way forward. It is for the Irish government to decide what they wish to do within Ireland, and the Oma families, of course, have the right to pursue all means at their disposal to try and find a satisfactory way forward. But I would just say about the Memorandum of Understanding, while we had exchange of views previously and are having them again today about what it may or may not produce, I think we need to see what comes out of the unprecedented commitment that the Irish government has given in the form of that MOU to cooperate with an inquiry in another jurisdiction. And we haven't got to the point yet where we see what information is made available, and the time to judge that is, I would say, is when we see what comes forward, rather than saying it's never going to work because it's not going to produce anything of any use.
Secretary of State, the Oma families will be sitting there today and will have only taken from your answers that you are not doing anything to push the Irish government to create a parallel inquiry, or through this negotiation encouraging them to engage in a way that doesn't answer whether it was solely the responsibility of the UK authorities to prevent this atrocity, but that the Irish have questions to answer as well. And as you know, in our last exchange I described the position as immoral and the stance as shameful, and I don't think there's anything of encouragement what you've said today for the Oma families.
Well, I wouldn't agree with that. And for those who are watching our exchanges today, as they did when we last discussed this, the Memorandum of Understanding provides the opportunity for information to be provided by the Irish government to the public inquiry. And that was
to answer one question, but not to answer the other side of a very important coin.
Well, of course I've discussed with the Irish government their position on having their own way of looking at it, but their position is well known, and in an agreement you're only able to agree things where both parties share the same view. But I think the time to make that judgment is not now about what the MOU will produce. It's when we see how the MOU works in practice, because it's not happened before. And if you think of other contexts, if you imagine the UK government cooperating with a public inquiry in another jurisdiction and saying that we will provide information, I can't think of any parallels, and that's why I welcome the memorandum of understanding as being a step forward. And I know you take a different view, but we will probably have to agree to disagree on that. Okay.
There's no question that Obabom had a cross-border dimension, and it is absolutely right in terms of getting at truth for the families, that it should have disclosure and participation, which is why it was a huge error of the previous government to establish an inquiry with no legislative vehicle, no defined MOU, no vehicle to have active participation from any state representative, no Gardaí, no army intelligence, and no diplomacy. And it's the will of the Assembly as well that inquiry will have full participation in whatever way that can be worked out. But in the disclosure MOU, it says as well that there may be redactions, include at paragraph 36, including matters that may damage the economic interests of Ireland or the UK. What has that got to do with getting to the truth of an atrocity? And do you have any anxiety about what information such a broad clause might cover up?
Well, in the MOU,
in the disclosure
that is something that the Irish have put into the MOU, and I think one would have to ask them the question: what did you have?
Do you have any anxiety about what might that uncover or cover?
It depends in what circumstances that was operated. I should just add that as well as providing information, there is also an undertaking to ensure that witnesses from Ireland can be called, and that too is extremely welcome. It's a very long memorandum of understanding, and it does reflect the unprecedented nature of the cooperation which the Irish government is offering to the OMA inquiry, which is referred to on a number of occasions when you read the full text of it. I think that's what I would say.
We'll pick up on disclosure, but the families are participating in hope and after decades, and I know it is just incumbent on everybody to make sure that their investment of time and energy and all others should not be in vain. It's important that they get maximum disclosure from that, and broad clauses like that, with all that we know about suppression of information over the decades, do not set the tone very well. Thank you.
Thank you. Moving on, Dr. Al Pinkerton.
Thank you, and thank you all for being here this morning. I'm going to move us on to a package of questions about the ICRIR. So over the last few months as a committee, we've taken a lot of evidence from witnesses about the faith or the lack of faith that they have in the ICRIR, and that lack of faith seems to spring from the realisation, the belief that the ICRIR is a product of the Legacy Act, which of course it is, and that there's a sense that the Legacy Act was introduced purely to curtail investigations into veterans. And because the ICRIR is a child of Legacy Act, there is distrust that has been expressed about that particular institution, even if there's a faith in those who are leading it. So can I ask you what the government intends to do to address those concerns and to try and gain trust from across all communities in a reformed commission?
Well, I think the lack of trust on the part of quite a lot of people in Northern Ireland in the Commission, in the form and circumstances in which it was created, stem from two things. One is the wider context, everything else shut down, inquests that were taking place, closed, civil cases stopped, and in respect of civil cases, the courts have found that was not compliant with our international obligations. We're committed to restore those. I've indicated that we'll be restoring the inquests that were actually shut down that had started. So that's one part, and that may or may not change public attitudes because the context is different. And the second is goes to the heart of the way in which the Commission is structured and worked, and I have made it quite clear that I'm looking for significant reform. I've talked about an oversight body, going back to the principles of Stormont House. I think when all of this becomes apparent and the legislation is published, it will be quite interesting for those who are looking carefully at it to map what we're proposing to do against the principles of the Stormont House Agreement, which was the last time there was an agreement between the UK government and the Irish government and a number of the parties in Northern Ireland, but not all of them. So that's the first thing. Secondly, I've already mentioned the victims panel, put that on a statutory basis. That is drawing on the experience of Canova. Much clearer arrangements dealing with conflicts of interest, which Stormont House addressed. The current arrangements don't give confidence to people. The ability to hold public hearings through the inquisitorial procedure, which is something that the Commission decided to create for itself, and I said a long time ago, well, I welcome that very much indeed, because public hearings is part of what will give people confidence in certain cases that the body is doing a decent job. And I think the last thing I would say is obviously there is a growing number of families who have now decided to go to commission. I've met in my consultation, I've talked to a very large number of people, and I know consultation, we may come on to this as a topic, have said, well, we've had discussions, but we're not sure we've been listened to. And I think I said to you last time, well, nobody can really know whether they've been listened to until they see the outcome of the listening exercise that I have been engaged in. But the fact that they've now got, 78, 79 investigations underway, over 200 people have approached them, some very high-profile cases arising from the Troubles, now the M62 bombing, Warren Point, Guildford, and others. Now the test, I've said this repeatedly, the test in the end will be, does all of this succeed? A significant reform commission, given the nature of your question, Mr. Pinkerton, does all of this create confidence? And what will really create confidence is, does it provide answers to families who've been looking to them for so long? And that will be the proof of the Commission in its reformed form as to whether it does what those families are looking for. And I hope that when people see the full shape of it, that there will be a movement in, it won't be all, because there are some who say we will never be reconciled to this. There are some who said to me, not a single person will go to the Commission, not one. Well, I'm afraid evidence has proved that that is not the case. And I did take a decision which was very unpopular with some people, right at the beginning, that I wasn't going to scrap it and start again, but I was going to reform it, both because time is not on anyone's side, and there's some very elderly people waiting for answers, and what is the purpose in losing time? And secondly, if you're going to abolish it to end up recreating something that looks very much like the reformed ICRIR that I have in mind, what is the purpose in doing that? Now, I stand by that decision, but I have been, of course, criticised, people perfectly entitled to, for having decided to do that.
You mentioned some of the, I guess, evolution of practice in ICRIR over time and the public hearings and that inquisitorial procedure. Are you going to make the necessary legislative changes to give ICRIR all of the powers that it needs to undertake investigations? Because at the moment, the legislative envelope is more around reviews, and the ICRIR themselves have said that they would like to have the powers required to undertake and to start investigations.
Well, they are undertaking investigations as we speak. And the courts have recognised, while they have found some things that they say are not compliant in relation to representation for families in the public hearings, what they've called the EIP in the past, and on disclosure. And I told the House last December what I proposed to do in respect of those two things to ensure that the Commission is compliant, because it's got to be human rights compliant. That is a fundamental objective of the reform process. The reform process has been made more complicated by the fact that the courts have been opining in real time on the Commission and therefore the nature of the reform that needs to be undertaken to make sure that it is compliant. I know there are those who have said, well, all it does is, a desktop review, a bit of this, that and the other. That is not the case currently. and they have a role both in relation to investigations, but also where that part can't lead to anything, to provide information to families, because a lot of the families, as you will know, that we've all met and heard from, some will say, I want justice, I want a legal process, but quite a lot will say, I just want to find out what happened. Did you want to add?
That's correct.
Yeah, okay. Thank you.
Okay, thank you very much. Katrina Murray.
Thank you. Apologies for lateness. I had a meeting with the largest employer in my constituency, so it's a shame that all these things happen at the same time. I'm interested in picking up on one of the things that you'd referred to in your answer to Dr. Pinkerton, that you referred to conflicts of interest within ICRIR, and it's something that we very much as a committee have heard witnesses arguing that the Commission itself should not include ex-RUC or PSNI officers amongst its senior commissioners, or potentially amongst any of its staff. And the example of Canova used as why this is necessary. What's your view on those criticisms?
Well, I think it's important to draw on all experience, including investigative experiences available. I would not support saying just because you served in the RUC you cannot have anything to do with investigations. That, as I understand, is not the view of Sir Declan Morgan. I think he was questioned on that by the committee. But clearly, where there is an actual conflict of interest, because someone may have been involved in dealing with that case in the past, I think it's very important that you have a clear statutory arrangement for dealing with conflicts of interest. And there may be cases where the Commission says, well, for the sake of confidence in the investigation, we should give it to investigators who have not served. I think because there can be some circumstances in which it's an advantage to have someone who understands how things and processes were working at the time, if you're going to have a proper investigation. So you need to strike a balance. But I am absolutely clear that to create greater confidence in the work of the Commission, that conflicts of interest are put on a much clearer footing in the legislation to command greater public support. So I'm very alive to that argument.
Okay, so that then picks up the yes, we all want to have processes that have the confidence of all communities and everybody involved. It then goes to the how are you going to achieve that, or how collectively are we going to achieve that?
Well, I hope that when I say I've been listening very carefully in the very large number of meetings that I've had with a very wide group of people, I mean it. And I've gone away and said, well, on this point, and this point, and this point, what's the merit in doing something about that? And when the draft legislation is published, then I hope those people who have met me and given me the benefit of their experience and their views will be able to look and see to what extent they feel, well, the government has listened to what I said. Now, some may say, well, you haven't listened. So the people who argue the Commission is irredeemable, unreformable, should be scrapped, they are not going to be satisfied, because I took a decision early on for reasons of timing and pragmatism, as I've already indicated in answer to the previous question, that we will keep it, but we will fundamentally reform it. And I mean, the proof will be in what people make of the legislation, how it works in practice. Does it provide answers? That is the ultimate test, the ultimate judge. And if families come out and say, yep, it has given me something, it may not be all the answers, but it's given me something I've never had in 20, 30, 40 years, then I think that's really important in helping Northern Ireland society traumatised by the Troubles to move forward, and particularly those families.
See, one of the other things that we've heard, one of the other things that we've heard is there's a real benefit to the internationalisation, particularly through the Canova process. Do you see there being a role for for an internationalisation, namely officers from the rest of the foreign nations potentially being involved?
Well, as I indicated in answer to an earlier question, the oversight board that we're looking to establish will invite applications, and those can come from people from any jurisdiction with a wide range of experience. And of course, the appointments to those boards will, one hopes, will offer the people you're referring to and asking the question confidence that, right, this is a very different arrangement to the way in which ICRIR was set up by the Legacy Act, which has not commanded confidence.
Okay, thanks. Thank you. Gavin Robinson.
Thanks, Chair. Secretary of State, you will know that both during our inquiry and in a lot of public commentary, there has been quite a number of comments that are deeply prejudicial and at times personal when considering the issues around conflict of interest. And I have discussed with you in the past my frustration, it seems, at sometimes the lack of support for individuals just because they had an RUC past. And I think you've fairly said that there is a conflict of interest policy within ICRIR. It's always been there. You're intending to put it on a statutory footing, as I understand it. That's a good thing. And I think you have rightly said that where there is a genuine conflict of interest, then somebody should not be involved if they have pre-involvement or previous involvement with that case, or even if they were in a managerial structure that meant that they had oversight of that case. I think it is fair to say as well. But in your answer to Ms Murray, you also mentioned that instances where there may be a need to withdraw to ensure confidence in the investigation. And that becomes slightly murkier, and that is certainly not assisted by the commentary we've had from very senior people, including the Chief Commissioner of the Human Rights Commission, senior individuals in Canova, senior members of the oversight body of Canova who have been long involved in oversight of police activities in Northern Ireland. And so I want to ask you, one, what would the criteria be for determining that somebody should recluse themselves because of perception or to build confidence? And two, how damaging do you think it has been that such individuals have strayed into the prejudicial slurs that they have rather than dealing with the facts?
Well, as I've learned from starting from the very beginning of dealing with this, lots of people say lots of things. They're not things that I have said. Indeed, I have said that I have confidence in the leadership of the Commission. I think that's very important. People, of course, are entitled to their opinion. I think it's a mistake to focus on individuals. The question is there a structure that can give people confidence that cases will be looked at fairly? I mean, that is the approach that I would take, and it will be, I mean, ultimately be for the Commission because it's an independent body. The legislative framework is set by the government, but it is an independent body, and that's very important. The Secretary of State is not giving them instructions, although some people's perception is that's the way it was set up. Well, that's not the way it works, and it certainly won't work in that way with me. It will be for the Commission to apply the framework that we will set out to particular cases. But I think focus on the structure, the issues, the way the Commission works, and not on individuals. I don't think that is, myself, terribly helpful.
I agree, but it's the prejudicial part of the comments that have been made and the fact that that may impinge upon confidence. And you have mentioned that if somebody may need to recluse themselves if there's a need to encourage confidence in the process. And my fear is that unless we repudiate the prejudicial comments that have been made, then we'll only add weight to the ability for people to create the perception of prejudice where none exists. And I think that's worrying. And so you are the person that is going to put on a statutory footing this conflict of interest policy. So I'm asking you to outline what criteria should we be considering in our oversight role when assessing whether there's a prejudicial aspect to confidence in this conflict of interest.
That's a judgment the Commission would have to make in the circumstances. And one of the tasks that we're all engaged in here is how to command greater confidence in precisely these legacy process, given that there are a lot of people who don't have confidence in them at the moment.
Yeah. And so some of that politically is very much an individual served in the RUC. We don't like him. And he served in the RUC, he lived in the Northwest, he is a Catholic. We don't like him. That's the nub of some of the commentary that has been made, not by everybody. There are others that just raise perceptions around conflicts of interest, that's fine. Some of it has been deeply prejudicial and deeply personal.
Yeah, well, so that's why
as Secretary of State, I think it would be very useful to hear from you.
Yeah, well, that's why I've said repeatedly that I have confidence in the leadership of the Commission, and I really don't think it helps to attack people on that basis. But the Commission needs to have effective mechanisms for dealing with conflicts of interest or apparent conflicts of interest. That is something that it will be for the Commission to sort out within the framework that I'm intending to put in place.
Secretary of State,
yeah.
I want to turn my questions to the Canova report, the final
Yes.
report. We are looking forward to seeing it published and completed, but just wanted to ask, that when it is published, will it be able to name steak knife?
Right, I met Sir Ian Livingstone last week, and following up on the exchange we had about 3 months ago, I went away and checked that the letter to him responding to the recommendations has gone, and the letter in relation to his separate request referring to the naming of steak knife. And I think I'm right in saying that the letter responding on the recommendations is now in the library of the House, so it's available for colleagues to see, and I assume will be published in the final Canova report when it comes out. What I said in my letter to Sir Ian was the government holds the view that NCND is a very important policy for reasons that are long established and well set out. There is a very important court case, the Thompson case, which has been heard in the Supreme Court, but we are waiting for the judgment, and therefore I've said to him that on this particular question we will come back to Canova after we have received the Thompson judgment. That's what I've said to him.
Though I assume that the Canova report will be published before the judgment.
It may or it may not, and that depends when the Supreme Court decides to deliver a judgment in the Thompson case, which is obviously not in my control. But even if Canova has published, the government is still able to reflect on the request that was made and make a decision once we have seen what the Thompson judgment has to say.
But if a pointed determination on of a Supreme Court judgment, I have to be very careful, obviously this is sub judice, is not related to the government's policy of neither confirm nor deny, then is there a reason why it can't?
Well, I think NCND is at the heart, absolutely the heart of the Thompson case.
But it's a government policy rather than pointed determination.
Well, yes, it is a government policy, but it's being queried in the Thompson case, and I have no idea, of course, what the Supreme Court will say, but the government's view is it would be sensible to have the benefit of that judgment before making a final decision in relation to the request that the Canova inquiry made of us regarding the naming of steak knife.
Yeah, and so assuming that Canova doesn't and can't then publish the name of steak knife, is there wider consideration that the government, at the appropriate moment in time, so I would assume post the Supreme Court cases being decided on, that you as a government would be able to name steak knife on the floor of the House?
Well, you're asking me to presume what the government's decision would be after the Supreme Court judgment, which, though you kindly invite me to do so, I'm not going to do so before the Select Committee today. What I've said to Sir Ian in my reply is the government will return to this matter after the judgment.
David Smith.
Thanks, Chair. Welcome, Secretary of State, all of you. Returning to ICRIR and the structure of it, when you told us in June that you're actively considering the proposal to split the investigative and information retrieval functions of ICRIR into two separate firewall bodies, as originally envisaged in the Stormont House Agreement. First of all, is that still the intention with where we've got to on the replacement? And it's also, what impact, if any, would you expect that to have on the timeliness for families to receive the information or the justice that they're looking for?
Well, there's a very important question, and there are two aspects to it, because the Commission has two functions. One is investigative, where they think there is a case that they can investigate, but also to provide information and answers for families. And I think there is great benefit in having the two things together in the Commission. However, I'm well aware of what Stormont House proposed, and I think there is merit in a separate information retrieval body, which would allow folk to come forward and disclose information that may assist families in finding answers. There are some practical questions in relation to that, which we are considering and have been discussing, including with the Irish government, because it was envisaged this would be a body jointly between the UK and Ireland, is one, in what order does that process take place? And number two, and it's a point that you have touched upon in the evidence that you've taken, is, well, how do you check that what has been... Someone comes along and says, I want to reveal the following. How do you check that whether what they have said squares with what other information is available about the event, the circumstances, the killing, and so on and so forth? So you'd have to find a way of ensuring that, because the families would be told, an unidentified person has come along and said the following, and they say, well, do you think that's true? And therefore I think some means of checking that information would be important in trying to take this forward.
Perhaps come back to that question of verification in a moment, but
yeah.
In terms of the firewalling of these two things, it was envisaged in the Stormont House Agreement that there would be a presumption of inadmissibility for investigations or criminal prosecutions in the information recovery part.
Yes.
Would that be something that you continue to envisage?
Well, that was the basis on which Stormont House was agreed. It is the basis on which the ICLVR, which is succeeded in recovering the remains of a number of people murdered and disappeared by the IRA and buried. They are searching again, I think I'm right in saying as we speak, for Columba McVeigh. His family and all of the families have been through so much. But there is, of course, a very big difference between a protected disclosure and the immunity provisions in the Act, which never came into being and were struck down by the courts, and which the government is going to remove. Because as the ICLVR experience demonstrated, society in Northern Ireland had to decide, are we prepared to give that protected disclosure to individuals in return for the recovery of the remains of people who were murdered and disappeared. And I wasn't party, obviously, to the decision at the time. I think it was the right thing to do, because the remains of a significant number of people, not all that disappeared, but a significant number, have been returned to their families to be laid to rest. And I think that was a good thing, and I think it was a sensible thing to do.
No question, sticking with the question of that information recovery, there's been a bit of a part of the problem over the last few years since the Legacy Act was introduced is a perception of, in some quarters, of inequity between those who may be subject to information recovery or the processes that the Legacy Act introduced, especially in relation to state actors versus non-state actors. And we've discussed before, one of the challenges in this whole process of information recovery is how do you actually ascertain the information in relation to non-state actors. So how do you envisage that information of the actions of non-state actors throughout the Troubles being substantiated? And might it draw upon the Stormont House Agreement, Canova? We've talked about the Independent Commission for the Location of Victims' Remains. How would you see especially those non-state actors being involved in this, and especially from the position of recovering information?
I think the first thing I would say is that information retrieval mechanisms should be available to anyone who wants to come forward and provide information for families. I think that's important. Now, the presumption is it will be non-state actors who will be making use of it, but that may not be the case in all circumstances. But secondly, I think it's fairly clear that the body to then go to say, have you got any, can you check this, have you got any information, would be in my view, the Commission itself. Because who else is going to do that? Because depending on what is finally decided in terms of the order, if you've said, well, the Commission has looked at it and has gone as far as it can, but then someone comes along and says, I'm now going to provide some information through the information retrieval mechanism, the body that has, well, as much information as is in its possession about the circumstances of the death would seem to me to be the sensible place to go to and say, this disclosure has been made, is there any commentary, assessment that you can make of this to assist the families in trying to understand how much weight should I put on this, does it assist me in finding answers? That would seem to me to be the sensible way of proceeding. Yeah?
Thank you.
Okay, thank you.
Okay, thank you. Dr. Alpington.
Thank you. This is a very natural segue, I think, from my colleagues' questions, and it's about the rules of referral to the ICRIR. Now, at the moment, I think there are a few quirks and peculiarities in that referral mechanism. I mean, clearly, family members can refer. As Secretary of State, you can as well, coroners and the Attorney General. But the Police Service of Northern Ireland have raised an issue where they don't have a clear pathway to refer cases to the ICRIR. And in fact, they gave evidence to suggest that they found a workaround that involved them reporting a case to the Secretary of State, and then you referred it on. But they also said that that wasn't a sustainable long-term solution. So can I ask, in the repeal and replace, have you thought about that? And what changes do you intend to make?
Certainly have thought about it, because it seems a roundabout route. I get a letter saying, well, we'd like this to be investigated, but we can't post it direct to the Commission, so we're going to post it to you, and then you can put another stamp on it and post it on to the Commission. It doesn't seem very sensible to me, and therefore we are indeed looking at giving the DPP, the PSNI and the Police Ombudsman the ability to refer cases direct.
And thank you for that. That's really important clarification. I mean, that's a simplification of a workaround that had come into being. But there's a broader question, I think, about the demand-led nature of the work of the ICRIR and the fact that somebody needs to come to them with a request. And I suppose the question fundamentally is, should the RIR have powers to initiate their own investigations?
Well, we are thinking about that. I think I'm right in saying that one of the requests I received was to say we'd like to link this investigation. Have I got that right? This investigation to another investigation, and I said fine. I hope I said fine.
You did.
I did say fine. Right. In which case, on the basis of what I've just said to you, Dr. Pinkerton, seem reasonably sensible to say commissions can see a connection there. Can we make that connection ourselves? But we're still, I think we're still reflecting on precisely how that might work. I mean, it's very much a demand-led model, and that is principally families, but we will end up with a larger group of people who have the ability to refer cases in. Now, of course, there are some families who said, no way ever do I want the case to go anywhere near it. But once we have fixed the human rights incompatibilities, then it is a fully and perfectly compliant body to fulfil obligations, which of course are different on where state has been involved, because there's a particular requirement relating to Article 2 compliant investigations that doesn't apply to non-state actors. That is just the way that the law works, which is why in some cases the courts have said, I'm afraid all the stuff that's happened is not Article 2 compliant. Once we've done that, then I think I hope it will be an effective means of providing answers. And some families may say we don't want it to go there, but we know that for some of the cases I mentioned a little earlier, a family member from one of the families has asked for it to go in. Now, there may be family members who are also affected by the terrible killing who haven't felt like that, but once the case is before the Commission, when you've had multiple deaths as a result of terrorist activity, one family member can refer it in, and then the Commission looks at it.
I'm really grateful for that answer, and that widening of the degrees of freedom that you talked about, where perhaps an associated investigation could be linked to a current one. I can see how that is a very helpful evolution in creating a new pathway for investigation, but it doesn't get around the issue that that there could be another case that the ICRIR might be motivated to investigate where that connection to an existing case can't be demonstrated, which would require them to set up something new.
Would you like to comment on that? Please.
Yes, so we are looking at the circumstances in which the Commission might be able to self-initiate an investigation or review. Secretary talked about linked cases, but there may be other circumstances, for example, where there may be an outstanding Article 2, Article 3 obligation that might merit an investigation. So we are still discussing that. It's not finalised, but we are looking at other circumstances in which the Commission might begin its own investigation.
Well, we look forward to more detail on that as it comes. Thank you.
Thank you.
Thank you. Gavin Robinson.
Thanks, Chair. In Secretary of State, inquests.
Yeah.
Whenever the Legacy Act was passed in 2023, I think there were 38 inquests that were stopped, and 24 of them really hadn't got going. 14 of them were in train but had not concluded their findings. Are we to understand that the 24 that had not yet commenced will go straight to the Commission?
I've made it clear that those that had already started will resume. For the others, there are two issues. The first is, what is the speediest and most effective way of making progress at looking at a particular case? Because as I've come to learn more about the inquest process in Northern Ireland, I think it's fair to say it has been exceedingly slow, and there have been some inquests that were started and appeared to end, and then new inquests have been ordered. So what is the most effective means to try and get answers for families, number one? And number two is the question of sensitive information, because we know from a number of the inquest cases that coroners have said, I'm sorry, I can't take this any further because I do not have the capacity to deal with sensitive information. As the committee will be well aware, if a PII application is made, the coroner looks at it and decides whether he or she thinks that the government has or others have made a case for the PII. They see everything, but then if they accept the PII application, they are not able to draw on that in taking the inquest forward, which has led a number to say, can't take it any further. The difference about the Commission and their inquisitorial mechanism is that the Commission will be able to deal with sensitive information. So what we're wrestling with at the moment is what is the best means of balancing those 2 points in deciding what happens to the rest of the inquests.
The rest of?
The rest other than the ones that had started and
my question to you was, are we to assume that the 24 that have not commenced will go straight to the Commission? Not so, you say?
No, it wouldn't be right to assume that. What I'm putting to the committee is there will need to be a mechanism for determining the answer to the very fair question you've asked.
And in relation to the 14 then, those that have commenced, are we to understand that all of those will continue, or continue to the point at which the coroner has to assess a PII, and therefore they may go to the Commission as well?
Well, it depends. Those that had started, that actually begun, yes, I've said repeatedly, will be restored. How they then unfold depends on the considerations that I've just set out to the committee, in particular in relation to sensitive information, because we know from previous experience there are coroners who said, I'm afraid I can't take this any further. So, in effect, the inquest has come to a stop. Now, clearly, the cases need to be investigated, and it would be sensible for them to go into the Commission, which can deal with sensitive information. In some other cases, coroners have decided, the coroners are entirely independent, it's a matter for them, well, notwithstanding the issue, I'm going to try and plough on to reach a decision. So, the answer to your question is, it depends how those inquests unfold.
And who makes the determination on closed material? Is that the coroner?
The coroner decides whether to accept the PII application. That has been the case for a very, very long time.
And that's issued by you, or
it's
the police,
issued by me. Who else?
Security services?
And the police, yes.
The owner of the information.
Pardon?
The owner of the information.
Yeah, the owner of the information is responsible for doing that.
That
the
could
coroner's
be police,
yeah.
Could be security service, could be anybody who has information.
Who has, yes.
From the state.
The relevant holder of the
information. The relevant holder of the information. The coroner sees all of it.
Yes.
But as we know in cases, the coroner said, yeah, I accept that the government or the other holder of the information has made a very valid case as to why this information should not be disclosed, but the rules of the inquest prevent that information from then being drawn upon by the coroner. That will not be the case in the Commission. Okay?
And you know, and you said earlier in this session that there are a lot of people say a lot of things. Right? You can't be expected to comment on them all. I understand that. But the current discourse around inquests is that there are 14 that should be re-engaged when you make an announcement on legacy, and that half of them will go to the Commission, and only half of them will proceed to full coronial process. So that comment is based on a sort of notional working through the criteria that you will publish. That comment is very clearly suggesting that whatever process is going to be gone through, a desktop exercise has identified 7 will proceed and 7 will go to the Commission. Do you recognise that?
Sorry, whose comment are you referring to?
Well, I'm talking about comments.
Comments?
Comments. The general discourse on inquests, right?
I've got a hard enough job trying to sort this all out without spending all of my time commenting on other people's comments.
In terms of confidence in this process,
yeah.
Should people be surprised if half of the inquest, half of the 7, don't proceed to full inquest?
I think we're just going to have to wait and see the process that we put in place and how it unfolds. Yes. I can't prejudge or anticipate that. I've tried to be as open as I possibly can with the Commission. Apologies, not with the Commission, with the Select Committee, in setting out the considerations that we are looking at and deciding how to take the question of the inquest forward. Okay.
If I was in fair form, Secretary of State, I would say that's a fair answer.
I will take it as a compliment.
Okay.
With alacrity, thank you.
Secretary of State, do you intend to reinstate all inquests or only those that were paused by the Legacy Act? And do you see the merit in people wanting to seek fresh inquests?
Well, I think I answered the first part of your question in answer to Mr. Robinson, when I said that those that had started and were terminated by the portcullis coming down under the Legacy Act will be reinstated. As for the rest, we're giving consideration to how what is the most effective means of taking those forward and what part sensitive information may play in the ability of inquests to conclude their task. I would say, secondly, we are looking to move, in putting all of this effort, money, legislation relating to a reformed commission, to move the finding of answers to questions into the commission as the most effective means of trying to enable cases to be investigated and for answers to be provided to families.
Okay, that's useful. You didn't seek, though, to reinstate inquests through the draft remedial order?
No,
so why not?
Yes, the reason for that was you can only use a remedial order if you're not appealing. If you're not appealing any aspect of the judgment relating to that item, and because the government is, I think, as I explained, may have explained previously to committee, and certainly explained to the House in December last year, I have said to the House, in respect of the judgment of the court, to do with cases where they're being considered through what ICRIR has called the enhanced inquisitorial procedure. The court said, well, if there isn't effective representation for families, then it's not compliant. That's what the court said. And I said to the House, I will remedy that in respect of the Commission. But there are broader implications of that aspect of the judgment, which is forming the basis of our appeal, Dylan being the lead case, and that is going to be heard next month in the Supreme Court. And because you're appealing part of an aspect of a judgment, you can't remedy the other bit using a remedial order.
So all of that being said, when do you then intend to lay the remedial order?
It is my intention to lay it alongside the draft legislation. And we have been giving careful consideration to the Joint Committee on Human Rights.
Although they did report in February of this year, I believe, so there's been quite a distance of time.
Well, indeed, but I think there's great merit in laying out the whole picture at one moment, and that's why I'm telling the committee it is my intention to lay the revised. I've published the proposed draft remedial order. I did that in, was it December or January?
December.
When?
December.
In December. So people have already had a chance to see the shape of that, considering the Joint Committee on Human Rights, and other people have commented upon it. But it is my intention to lay the draft remedial order, which is the second part of the process, at the same time as the draft legislation is published.
Okay, a really key issue in all of this is going to be the issue of funding and how any new inquests or inquests that were put on hold by the Legacy Act are going to be funded. The Law Society, amongst others, has said that the resumption of legacy inquests requires proper resourcing so that they can proceed in an expeditious and efficient way, something that you yourself this morning have outlined as a key priority for you. That being said, the funding issues within the Northern Ireland Executive and also in the Department of Justice have been well made and something that you will know about.
Yep.
Is it then therefore fair or appropriate to expect those either stalled inquests or any potential fresh inquests to be funded through resource money in DOJ?
When the 5-year plan was put in place by Declan Morgan before he became the involved in leading ICRIR, funding was identified for those inquests. So if funding was identified for those inquests, then it's there. Whether there will, how it will pan out, going back to Mr. Robertson's question, in respect of the other inquest, depends on the outcome of the consideration process that I've described to the committee. The funding for the Department of Justice, which covers inquests, policing and so on, is entirely a matter for the executive. I've done my bit, which is to, the government's done its bit to ensure that the Northern Ireland Executive is funded slightly above its level of need. Record settlements, the financial cliff edge, which the committee had been considering, which much talked about. No one's talking about the financial or fiscal cliff edge now because of the funding settlements we made available. And it does fall to the Northern Ireland Executive to decide how they're going to deploy their resources between all of the competing demands that all governments face.
If there are a resumption of inquests, it would probably be a fair assumption to make that they would be seeking to do that as soon as possible. There's potentially going to be a bottleneck of demand there. Are we to assume from your comments that you are saying that therefore the Northern Ireland Executive should fund this, despite the fact that the Legacy Act itself, previous, was ruled unlawful? Therefore the money in the past that was identified is no longer there, and the pressures within DOJ are so huge and very well known in terms of day-to-day running, policing, etc. Do you really expect people to think that it's right and proper for all of those processes to be funded within the Northern Ireland Executive whenever it's the actions of the previous government and others by stalling the process, then creating demand, which I think is a good thing? But how is that going to be met within any departmental budget?
Well, I think the first thing I would say is funding was identified, that's my clear understanding, within the Northern Ireland Executive for the 5-year programme. Now, has that been taken away? So the funding was identified from within Northern Ireland's resources, and therefore I would presume that it is still available for the cases that were listed as part of the 5-year programme, which, if I am correct, would include the ones that had started?
Yes.
Yeah. So the funding had already been identified within Northern Ireland for those cases. I grant you that funding had not been identified in relation to the 20 that the Attorney General for Northern Ireland referred in just before the deadline, the portcullis came down, and that what happens to those will be subject to the process that I've tried to be as open as possible with the committee about in answer to your and Mr. Robinson's questions. And we are putting money, of course, into the Commission, and if the Commission takes those cases, if that's how it pans out, then the UK government is funding that through the money that is available to the Commission to do its work. And finally, we have provided additional resources, and the executive takes decisions about how it's going to spend it.
Any intention to revisit the funding? Any intention to revisit the funding formula?
The funding formula
given
for Northern
everything
Ireland.
You've just said,
well,
and also given the fact that you have exceeded that actually only partially funded inquests there, not all of them, and clearly there will be a demand for people to want to. I think, Secretary of State, simply what I'm trying to get at here is that we all know around this table that the Northern Ireland Executive is struggling in terms of finance. There is not a spare penny in any department, to the best of my knowledge, and particularly not in DOJ. So it's a simple matter of common sense to say, is it right and proper that that is funded from entirely within the Northern Ireland Executive?
Well, I recognise the pressures that are on all governments in current circumstances all around the world. But Northern Ireland receives 24% additional funding compared to England. 24%, is slightly above that. Record settlement for the 3-year spending review. And in a separate context, I've always said all governments also face decisions about are there ways in which they can raise revenue to augment the resources they have available to meet the demands and the pressures that all services and all governments face. Now, those are choices for the Northern Ireland executive. My job, the government's job, is to make sure that the Northern Ireland executive is adequately funded, and the record settlement announced in the spending review does that because it meets the recognised additional need as identified by the Northern Ireland Fiscal Council of an additional 24%. That is the funding that we've made available.
Thank you.
Okay, thank you.
Okay, Ms. Poole.
Thank you, Chair. Welcome, Secretary of State. I'm going to touch on an issue now that I suspect many members of the committee have had addressed in their inboxes and in their community meetings, but that's of the issue of veterans.
Yeah.
And I know this is an issue that you took part in the Westminster Hall debate in response to the significant petition that came forward. And I suspect you will know that Mr Johnston also gave evidence to the committee as well. And many veterans are concerned about what they see as the fundamental unfairness of the inquest process, which they claim is disproportionately focused on the actions of state forces. How do you think you will be able to address those concerns moving forward?
Well, look, I do absolutely understand the concerns that the veterans have. I would say, first of all, that they were offered immunity that was never going to be capable of being delivered. It was never, of course, commenced by the last government, despite having put it in the Legacy Act. It was then found to be incompatible with our human rights obligations and was struck down by the courts in Northern Ireland. And this government came into being committed to removing it because we do not agree. And many people in Northern Ireland, it's one of the reasons why the Legacy Act was opposed by so many people in Northern Ireland when it was passed, because it was such a screeching 180-degree turn by the government from the approach that was in Stormont House, agreement between the Irish and British government, with not everyone's support in Northern Ireland, but a measure of support, to something that had nobody's support, which is why we're sitting here having this conversation about what needs to be done to address that. And we're not in favour of giving immunity to terrorists. Let's just be frank about that. That is the first point. The second point is there were no protections provided for veterans in the Legacy Act in engaging with legacy processes. And we're looking, and I've been talking to the Defence Secretary, the Veterans Minister, about putting a package of proposals together, which we will set out in due course. One example, I've already said, clearly with modern technology, there's absolutely no reason why a veteran should have to travel back to Northern Ireland in order to give evidence at either a remaining inquest or indeed the Commission. They ought to be able to do that remotely, because we do have an obligation to veterans to make sure, particularly a large number of them who served are now very elderly. But those are provisions that would obviously be made available to other witnesses as well. This is not just about veterans. Anyone who wants to give evidence remotely or is elderly and particular consideration needs to be given to their circumstances. I would also just address other things that veterans have said. The argument about the on-the-run letters. We had the Westminster Hall debate in July, and there were colleagues who got up and said, well, you've given immunity to terrorists in the form of the on-the-run letters. Not true. Really important that we're all clear that that is not the case. Now, you can debate the merits or otherwise of the on-the-run letters at the time, but as Lady Justice Hallett made absolutely crystal clear, they do not and have not granted immunity. What they said was, well, we have no reason to be interested in you, I paraphrase, at this particular moment in time. And the proof of that is there are at least two cases I'm aware of where individuals who had received on-the-run letters have then faced prosecution, which proves that on-the-run letters do not give immunity. And finally, I would say that the Cluno inquest. Go back to the question of inquest, because in the last year and a bit, there have been two inquests involving soldiers where the coroners said, yes, in these circumstances, the use of force was justified. Some people say inquests are skewed in one direction, commentary. People make comments saying it's not fair. But in those two cases, would they say that was a fair outcome if they're thinking about the interests of veterans? Because the inquest said, yeah, use of force was justified given the circumstances you found yourself in. But there's no doubt that the Clonot inquest verdict caused a great deal of consternation, which the government shares. And that is why, almost unprecedented fashion, the government has said, one, we will fund the veterans involved in that case to bring a judicial review. And secondly, the government itself will bring a judicial review. And I think the next phase of that will be a leave hearing in November, if I remember correctly. And that, I think, shows in that particular case, the government absolutely has at the backs of the veterans. And then, finally coming back to immunity, I've met many veterans who said, I don't want immunity. Indeed, when the Veterans Commissioners, and I know you took evidence, the 3 Veterans Commissioners issued a statement in connection with the Westminster Hall debate, and they said, this is not, and I quote, this is not a call for immunity from the law. I agree with that completely, but for fairness under it, and I agree with that too.
Thank you for that answer, Secretary of State. I think the issue is when there is a void of information or lack of clarity of when the situation will be clear for veterans, that is where actors can come in and muddy the waters as such. And so it would be good to know perhaps when you think some of those discussions with the Defence Secretary and the Veterans Minister might become public about what veterans may expect to happen in the future, because of course there is a concern about vexatious cases. You know, you've mentioned clearly that you'll make sure that the punishment that there'll be, you know, you won't bring over veterans and vexatious questions won't be the punishment for those people. But how will you, as Secretary of State, ensure that those vexatious claims don't get taken forward? How are we going to ensure that doesn't become part of the process moving forward?
Well, I certainly want the whole government's approach, including the support that we're going to provide to veterans. There was 250,000 people served in Operation Banner with great distinction in the most difficult circumstances. A large number of them were killed. They were there to try and keep people safe. And you are right. I think the Clonot inquest verdict in particular led people to say, well, is this what inquests henceforth are going to produce? All I would say is you need to look back, and an inquest process is independent, the commission process is independent, and they will form a judgment on the basis of the evidence. On the vexatious point, I do just want to say this, because it goes back to comments, which has been a theme of this evidence session. I have heard people say, they've talked about politically motivated prosecutions. Now, all of us round the table who are very concerned about the rule of law and the independence of the judiciary and prosecutorial decisions should be really alarmed when those phrases are used, or vexatious prosecutions. Who decides on prosecutions? Independent prosecutors. And I emphatically reject the suggestion that there have been politically motivated prosecutions or vexatious prosecutions. Because if we go down that road, we are in terrible trouble as a society. And language matters. It really matters in this case. Now, there is a separate question of civil cases, and veterans, have views in relation to that. It is ultimately and mainly for the Ministry of Defence to decide how to deal with those particular cases. But there's a lot of worry and fear. I accept that, and that is why it is important that, and I accept your point entirely, that the government provides clarity about the practical steps we're going to take to support veterans, while also upholding the principle of the law applies to everybody, and we're not going to give immunity to terrorists, which is the government's policy.
Thank you, Secretary.
Okay.
Robin Robinson.
Thanks very much, Chair. Language does matter, Secretary of State. Language does matter.
It does matter, yes.
So you'll accept that John Downey, the Hyde Park bomber, escaped prosecution on the basis of a letter of comfort. He was not prosecuted because of the letter of comfort, and the letters of comfort were not in isolation either. They came on the back of prisoner releases, a commitment that anyone convicted would only serve 2 years, the extension and the allocation of royal prerogative of mercy on quite a number of terrorist individuals, legislation introduced by a Labour government called on the runs legislation separate from the letter of comfort, which was a scheme, very open and very transparent, to allow people who had evaded justice to come home and retire with a level of dignity they did not afford their victims. So it's not right to either say that letters of comfort did not offer an amnesty, because in John Downey's case they did, and nor is it right to single out letters of comfort from the panoply of extravagance that successive Labour governments offered to terrorists. So I think it's fair to just put on the record, if we're saying that language matters, that there was not an isolated scheme to protect terrorists or to give some comfort to terrorists. There were successive schemes offered to terrorists, and that's the atmosphere created now about the fear that some veterans have. Now, I mentioned earlier that it seems as if comments made that inquests will be whittled down to 7 proceeding, and you're not going to comment on that, and that some of those involve soldiers. In the July Westminster Hall debate, I understand, and it was good of you to attend that, because it's very rare that you would have a Secretary of State in Westminster Hall. I think that was a credit to you. But I understood that for your Labour colleagues you were going to outline all the protections for veterans, and that didn't somehow come. But there was a suggestion that the protection being offered is that individuals don't have to travel. Individuals don't have to travel.
Yes, I've already said that to the committee. Yeah.
Is that the sum total?
No,
whenever we hear you earlier in the session and others outside of this room say that we are going to protect veterans, is the failure to have to travel some total protection for elderly veterans who fear being dragged through a prosecution process, which in the end could lead to a conviction, but with no time served?
Well, to be clear, the no need to travel would relate to inquest or hearings of the Commission. If I may, you've raised a number of points in putting that question. To go back to the start. In the case of Mr. Downey, and that is a matter of public record, the court reached its verdict in relation to the Hyde Park bombing, as I understand it, for particular reasons that were very specific to that particular case, and I know that caused a great deal of distress. But I would just point out, because it is a matter of public record, that Mr. Downey is currently facing prosecution for 2 other murders, which proves the point that I made earlier.
It absolutely doesn't. Well, you said that letters of comfort did not provide an amnesty and people are being prosecuted. People are being prosecuted. There was an inquiry. Lady Justice Hallett said that there should be no comfort provided by these letters. They amount to nothing more than a piece of paper. But it is true to say that John Downey walked out of court on the strength of the letter of comfort he had erroneously given, and was therefore not prosecuted for the Hyde Park bomb. And that's why I say language matters.
Well, as I understand it, the particular facts of that case, the court decided it was an abusive process. And we can all read the judgment and see the circumstance of that particular case. But to the argument that has been made, including in the Westminster Hall debate, that on-the-run letters of comfort, whatever you call them, mean that people have been given immunity from prosecution, that cannot be correct when it is a matter of public record. I'm not going to comment any further for understandable reasons, that Mr. Downey is currently facing prosecution for 2 murders.
Thank you.
Yes.
Claire Hannah.
Thank you very much. Secretary of State, disclosure, deciding who has the say over what information victims get from those who did the killing, whether in uniform or out, is, I think you might agree, at the centre of a lot of the paralysis, a lot of what has caused these cases, in many cases, to take decades to resolve, including touching on some of the issues you just discussed with Mr. Bloor. And I credit you for setting out some of the realities of that, but it is about who gets to control the information. And you discussed the Thompson case. That is one of the places where that is being fought over. And in the Supreme Court in June, in the public session, your department's barrister indicated that the Chief Constable might resign if you didn't and he reconcile on your analysis over what constitutes national security. The next day, your barrister did try to walk back that suggestion, but it was said, and it was said in public session. Can you explain how he came to make those comments?
I can't. They were his words, they were not mine, and as you say, the following day. I think it comes back to my point that I made earlier. It's not helpful to focus on individuals. There has been a difference of view about how PII should be approached between the government and the Chief Constable. But I don't think it's helpful to have a go at individuals.
I think, and I'm not going to insist you speculate, but I think people will wonder, was that a solo run, or was that idea put in his mind in terms of the thinking and the framing of this issue within the department? And if you could set out just your understanding of the, I suppose, your response to the Chief Constable's belief that it should be the judiciary that ultimately weighs up, and taking into account that the Chief Constable, this is not his first rodeo. He has a lengthy background in handling sensitive issues. But what is your response to his belief that it should be the judiciary that weighs up the competing needs of around disclosure?
Well, I would say this. First of all, the government's policy is we want the maximum disclosure to provide answers consistent with national security. Secondly, government ministers have responsibility for national security. They're set out quite clearly. They're ones that I take extremely seriously. Thirdly, I am committed, in the light of the court judgment relating to disclosure and the Commission, I am committed to undertaking reform so the disclosure arrangements that apply to the Commission are akin to those of a public inquiry. Now, the court said, well, we find this incompatible because it doesn't look like that which applies in a public inquiry, and I said that I want to get to the point where it does, so that incompatibility is remedied. In each case, what is actually disclosed comes down to a exchange of views, a discussion, and ultimately it is open to anyone to bring a judicial review against a decision, in which case the courts will finally determine what the outcome
creating
is.
The same layers of, as people say, of cases being relitigated and rehashed out, and creating further years of victims having to travel. And you will be aware of, and we've been talking about commentary, but I'm also talking about feelings about a family who are having to return back to the Supreme Court again. Can you understand the perception across the board of decent people and people who have put a lot of effort into developing confidence in policing and in processes? Can you understand that people are wondering who or what are calling the shots in London in terms of disclosure, in terms of release of material, when, as I say, families like the Browns are being dragged through another hearing, and when in open session in Supreme Court commentary like that is being made about the viability and the tenability of the Chief Constable's position by legal representation for the department? Can you understand why people are wondering who is calling the shots and what on earth is being covered up?
Well, I completely understand the frustration, the pain, the suffering of those families. I've met a number of them, and of course, including the Brown family, in still not knowing answers after all of these years. There's a particular reason why, in the case of the terrible murder of Sean Brown, we are appealing, because the issue of principle, which is not the concern of the Brown family, I understand that, is it is for governments to order public inquiries, not the courts. That has always been the position, and the courts in Northern Ireland decided in this particular case they would order a public inquiry to take place, and the government thinks it's right that is, if we get leave to appeal that decision, which was upheld by the Court of Appeal in Northern Ireland, to see whether the Supreme Court agrees that long-standing policy should change and the court should be able to decide when public inquiries are ordered, because I think it is a job for governments. I don't think it's a matter for the courts. But I do understand that, and in having made the commitment to Parliament in December that I will reform the disclosure provisions to make them akin to a public inquiry, because after all, the Commission is going to see everything. And I'm not aware in the work that it's undertaken so far that there have been any case where the Commission has said, I'd like to see this material, and they've been told, no, you can't see it. Those who hold the information are under obligation to provide it in full, unredacted form to the Commission so they can do their job and hopefully provide answers for those families. But I completely understand the frustration, the lack of confidence there's been in the Legacy Act in particular, which I am doing my best to try and remedy.
Can I just make clear to colleagues not to mention any live cases? Thank you very much.
We've discussed the neither confirm nor deny policy, and the Chief Constable outlined the way in which, from his experience, it is used liberally, prolifically, and he has said in a way that has stopped wrongdoing coming to notice and prevented people from being prosecuted for murder. And we've discussed, and I won't reopen the discussion that we just had about a case that we've discussed publicly and privately, the legal issues, but also the moral issues, and also the very, very wide public perception. Can you set out how you are intending to address those disclosures issues, how you are intending to respond to the Chief Constable and many, many others' request for a change in NCND policy and disclosure more widely?
Well, firstly, as I've already pointed out, the Commission gets full unredacted disclosure. Secondly, we'll amend the regime to ensure that it is consistent with other established mechanisms, which would seem to me to meet the issue that the Court of Appeal raised. There are wider issues to do with the court judgment, which is forming part of the Dillon hearing. It's right that we will then seek clarity from the Supreme Court. But I repeat what I said a moment ago, the power is not a veto.
It is a veto.
No, it is not a veto, because it can be challenged by way of judicial review, just like any other decision of a government minister or a public body. And if it can be challenged in the court, then ultimately it is the courts that decide.
Can you understand the perception that, as I say, these layers and just increasing kind of rivets and processes for decades that have been put over, files being sealed, disclosures, we've all seen documents with page after page of redaction. Can you understand the perception that if you say, we won't tell you until you have to come back to court, and then people going to court will have avenues shut off and will be demonised for lawfare and for doing so, that it doesn't feel like transparency, and that setting the truth free is the best way for us to truly move on, to go through some things that will be very ugly and very, very difficult for people to hear, but will be particularly difficult and embarrassing for those with things to hide, and particularly cathartic for those who need that truth to be able to move on with their lives, those who have been most wronged. And can you understand that until that is properly addressed and people don't have to, go to court and fight further and further and further, until that is proactively given, we are going to be stuck with this fog all around us, and hundreds of millions of pounds of legal processes before people can finally get to the truth. And really, that none of this is worth the paper it's written on, if the principle is still proactive holding down and proactive use of policies like neither confirm nor deny.
Well, I can only respond to that by saying I want the maximum possible disclosure to enable families to find answers, but there are considerations of national security, and there's no running away from those, that all governments have an obligation to give very serious weight to in deciding ultimately what is disclosed. Now, that's what happens at the moment through the PII process. And, I mean, many coroners have said, yes, I've looked at that, and yep, the government makes a fair case, and that happens on quite a regular basis. But I accept that I accept the point that you made about the frustration, the concern, the worry. People think this must have happened, and it may be when answers are ultimately provided, what people have thought did happen, it didn't happen, and answers may be uncomfortable in lots of different ways. And I do think that when the Operation Canova report is published, well, it had quite a lot to say in its interim report, and I welcome very much what Canova has done, because the way it's gone about it has informed the policy that I am in the process of developing, and which will form the basis of the legislation I intend to publish.
Okay, thank you. Sorted, stood.
One of the letters within the ICRIR stands for reconciliation, and I think some might consider that a misnomer at best or egregious at worst. There have been an awful lot of criticisms of ICRIR's ability to aid, promote, deliver reconciliation. What would be your response to those criticisms?
I read in the evidence that you have taken, there are those who've said, well, is there going to be a proper legal definition? I don't see how legislation can define what reconciliation is. Indeed, when I met a man whose brother had been murdered in the most brutal circumstances, he said to me, how can there be legislation that tells me that I must be reconciled to what happened to my loved one? And I said, I agree with you. Reconciliation in the end can only come from within, and come from justice and truth and disclosure and answers. And therefore, the job of the Commission is to try and provide those answers, and in the act of doing that, let us hope that it assists the process of reconciliation in Northern Ireland. Given the trauma that your society has been through.
Would it maybe be better to take it out of it then in all entirety?
Well, I'm certainly looking to change the name of the Commission, which is one of the points that's been put to you in the evidence that you have taken. I think that I accept that argument. It's not the primary focus. It is, if the Commission does its job and does it successfully, this will assist the process, but there isn't a part of its work that says, well, we've got a particular reconciliation strand, although there is.
Actually, Secretary of State, the ICRIR gave their own evidence, obviously, and they listed amongst a number of bullet points some of their key functions. And they list one of those themselves as objectively telling the unvarnished truths about the past. So they are trying to, in my opinion, provide a role where they can, in their own way, look at reconciliation. But for me and others, including the Northern Ireland Retired Police Officers Association, it's silent on how the ICRIR will ever be quantified in terms of having delivered reconciliation or monitored reconciliation. And a lot of people are looking at this, and given comments that my colleagues have made in this session today, there is a real concern that actually people could potentially come forward, terrorists, and tell their own story. We've already seen the wholesale rewriting of the past, in terms of people attempting to justify terrorism, in terms of people saying that that was what they did and that they would do it again. There's a new generation that are very, very porous in terms of what they're taking in, and how that impacts the Northern Ireland of today. And I really worry that in lieu of any mechanism to attest or corroborate the veracity of claims made by terrorists that could come forward, that really to have reconciliation as a word used in the same sentence is problematic.
If I'm wholly opposed to the rewriting of history, when I visited recently the wonderful exhibition on the Troubles at the Ulster Museum, there was a phrase in one of the panels that came out and struck me. It says, "We have a shared past, but we do not have a shared memory." And I thought that was really a very, very good way of summing up what you have gone to the heart of. Mrs.
I would just say, though, I agree, we don't have a shared memory, but I think it's incumbent on all of us to state that terrorism was always wrong.
Well, I agree with
always
that.
Wrong.
But I agree with
People
that.
are entitled to their own memory or whatever it may be, but we have to be open and upfront and without fear or favour in stating that no matter the circumstances. And my fear is that this element of reconciliation or terrorists coming forward it is giving them, a charter to rewrite their role in the Troubles, to give themselves even more of a platform. And although I agree with what you're saying, I personally, and I think all members should be upfront in saying that terrorism was never acceptable, and that there was always an alternative and that it was never justified.
I agree with every single word of that. And of course there was an alternative, because the alternative eventually appeared in the wake of the Good Friday Agreement, which has brought extraordinary progress to Northern Ireland society in the years since it was signed. Now, going back to the earlier question about information retrieval, if people come forward, we discussed back and forth how that information itself might be tested. But I remain of the view that in respect of the work of the Commission, it is what it does to help provide answers that I hope may assist in the process of reconciliation. And I'm not looking at trying to define it legally in the draft legislation I bring forward, because I don't think that is helpful for the reasons I've tried to set out in answering your questions.
Appreciate that. Thank you.
David Smith.
Thank you, Chair. There's no question, Secretary of State, that when it comes to reconciliation, the uncovering of truths and the sharing of information and the pursuit of justice are all part of the process of reconciliation. Yeah. And you said previously to us in this committee that it's not the role of the state to impose reconciliation on anyone, which is absolutely correct. However, it's also the role, or the possibility for the role, for the state to create the circumstances and the parameters and almost be the facilitator of a process in which that can happen. And symbolism really matters, memorialisation really matters, and I share some of the concerns of my colleague about the ability of ICRIR to do this, but it has, as you say, a place in that. This might be a slightly unfair question, but it seems to me that one thing is massively missing, both with the British state and with the Irish state, and with all stakeholders, really, non-state actors as well in this process, is the role of acknowledgement, the role of, it's a very old-fashioned word, but of even repentance, looking at the last, not just the last 40 years, but the last 1,000 years, and saying what really is our relationship between these islands. And I think of the Queen's visit to Ireland in 2011 and the massive positive impact that had. So I guess that's a big preamble to ask a question to say, what more can the British state, the Irish state do to lead by example, to incentivise others to acknowledge that wrongdoing was done, even in a more general sense, because that, to me, seems to be the thing that is missing here and is so often the elephant in the room.
Oh, it's a very large question, because if we're going back 800 years, and there's a long story. You know, when I was a student at school and first encountered the repeal, the Catholic Emancipation Act of, I think, 1829, if I was paying attention at the time, when you come to learn subsequently what went on in relation to the suppression of people's culture, their language, their ability to form jobs and do a whole host of things, truly shocking. And as you mentioned, the late Queen's visit, it was a remarkable moment, and then was reciprocated when President Higgins came and addressed both Houses of Parliament down there. The late Queen said something, and I'm not sure whether the quote is 100% correct. She said, "There are some things that we may wish we had done differently, or not at all." I thought that was a very profound observation, and also you could almost describe that as a statement of acknowledgement. There are a growing number of incidents now where the state has recognised that wrongs were done involving the state. I think of David Cameron's apology to the House of Commons in respect to Bloody Sunday, after the Bloody Sunday inquiry reported. I think of his apology for the shocking level of state collusion in the murder of Patrick Finucane. I think of what Boris Johnson and indeed Brandon Lewis said about Ballymurphy. I just give instances. It's important that all those who are involved come forward and tell the truth and apologise for what happened. And there's been a reluctance, going back to Miss Eastwood's question, on the part of those who did engage in terrorist violence to say, well, it was justifiable. And as we all agree, it was certainly not justifiable. But it's a process, and it takes time. And Northern Ireland society has moved on a lot. But having come into this job 14 months ago, it seems to me it is a society that is still traumatised by this legacy. Individual families, the overall impact that this has had, which is why all of us should do our darndest to try and find a way forward that can command greater confidence, give answers. If we search for the perfect and somehow believe that everyone in Northern Ireland will say, you've got it, it isn't going to happen. We know that. You know that from the evidence that you've taken in this inquiry that you've been undertaking. And nobody's going to get everything, in the famous words of Mo Molam. But let us hope that when we put all of this effort and energy together, that we can produce something that will enable us to move forward. I want us to be able to move forward, because the Legacy Act in particular, which is trying to fix it, occupied a very large amount of my time, just went backwards, which is why there was no support in Northern Ireland for it. And how can you make progress in Northern Ireland if you bring in a piece of legislation there's no support in Northern Ireland? Well, the answer's obvious. You can't. And that's why things have to change.
Okay, final question, Claire.
Thank you. I think that's very well said, Secretary, and it is fundamentally about moving forward. I think people think this is all obsession with the past, and it isn't. It's obsession with the future and getting it out. And I genuinely and truly believe that, you know, if there's disclosure and forthcomingness from the state, which is the bit that you have most control over, it will force those paramilitary organisations who are responsible for the sizable majority of killings. It will force virtuous circles, and it will remove the shackle, or remove the hiding places that they have in failing to disclose and failing to be honest. And David and Saoirse are entirely right about the non-legislative opportunities for killers and for killing organisations to take the initiative and step forward, and that to be more clarifying and more freeing than any amount of court actions, actually. But those are the things we have legislative control over. Briefly want to touch on PSNI funding. Week after week, the police set out the challenges that they are facing with the normal and the increasing pressures in all areas of life, and operating with around a fifth fewer police officers than needed and expected, as well as dealing with policing the past as well as everything else. The Chief Constable got sort of put in his box by DOJ when he went to London to try and raise this, and it appears he got tea and sympathy when he got here, and Ms Eastwood has touched on funding challenges across the board. Are you making a case to Treasury or whoever else? Are you able to advocate for increased funding and support for the PSNI, because those issues that inability to police the present right now, as well as issues that I've raised with you before around confidence and perception that flow from legacy, are really challenging the new beginning that is probably the most successful part of peace.
The case I've been making with the Treasury since I took up post is, of course, given my job, to get the best outcome for funding from the Northern Ireland Executive. But policing was devolved, it is devolved, those are decisions for the Executive to take. Now, I mean, there are those who come to me and say, can't you just ring-fence this bit of money, and can't you ring-fence that bit of money? Because we think this is really important. We don't think that the Northern Ireland Executive process is producing enough for this particular. And before very long, if you go down that road, well, we all know where you end up, and it is not devolved government. I believe passionately in devolved government in Northern Ireland. But with devolved government comes responsibility, and all governments have to take really, really tough decisions about prioritisation. And it is within the hands and the means of the Northern Ireland Executive to decide how much money it gives to the Department of Justice and therefore through to the PSNI. And what I've done is to do my part of that process, which is to make sure that the Northern Ireland Executive gets a decent settlement, a record settlement, and that is what the spending review has delivered. The rest is over to the elected politicians of Northern Ireland.
Okay, thank you. I'd like to take this opportunity to thank you, Secretary of State, for your time today and your office, and I'll say order, order.